Dear friends, a very warm welcome to all of you to the 38th AKG Memorial Lecture. An occasion we gather to honor the legacy of Comrade A.K. Gopalan, a fearless leader who dedicated his life to the struggles of the working class, the fight against oppression, and a vision of just and equitable society. This lecture series, organized annually by Jana Sanskriti, serves as a platform for intellectual and social discourse, carrying forward AKG's ideas. For the past 45 years, Jana Sanskriti was promoting progressive thoughts, cultural activism, and democratic engagement in Delhi NCR. With the 22 active branches, working tirelessly to uphold society harmony. This lecture series has been enriched by the insights of numerous distinguished speakers over the years, including Professor Prabhat Patnaik, Sri E.M.S. Namboodiripad, Dr. Sunil P. Ilaidam, Sitaram Yechuri, V.S. Achyutanandan, Professor Ram Buniyani, Dr. T.M. Krishna, Dr. Pravir Burkaesta. Their contribution has significantly shaped our discourse and actions towards building a just society. A special and hearty welcome to our distinguished speaker, Justice K. Chandru, former Madras High Court Judge. Justice Chandru is known as for his integrity and commitment to social justice. Throughout his career, he was delivered nearly 96,000 judgments, advancing labor rights, gender justice, and upholding constitutional values. His dedication to justice inspired the film J-Beam, highlighting his pursuit of equality, gender justice, and constitutional values. Welcoming. Now, I would like to welcome our President Sri Vinod Kamalat and our Treasurer Sujata Baby. I would also warmly welcome to our friends from the media who are here covered this event and help spread the message of justice, equality, and constitutional values. We deeply appreciate your role in amplifying these important discussions. A special welcome to leaders from various progressive organizations who continues to work towards a more just and inclusive society. Your presence strengthens our collective struggle for equity and social transformation. Finally, but the most importantly, I extend my heartfelt welcome to each and every one of you, activists, students, intellectuals, and citizens who believes in the power of ideas and social change. Your participation in this discussion reaffirms that the ideas of AKG and Ambedkar continue to inspire and guide us. The theme of this year's lecture, Constitution and Ambedkar on Today's Perspectives, is of great relevance and current socio-political climate. As we witness increasing challenges to constitutional values, it is imperative to revisit Ambedkar visions and explore ways to uphold to the principles of justice, liberty, equality, and fraternity. Justice Chandru insight today will provide us with a deeper understanding of these issues and inspire us to continue the fight for a truly democratic society. With these words, I once again extend my warmest welcome to Justice K. Chandru, our esteemed guests, media representatives, progressive leaders, and all of you in the audience. Let us engage, reflect, and reaffirm our commitment to the value that AKG and Ambedkar so passionately fought for. Now I would like to call our chair, Mr. Vinod Kamalat, for further proceedings. Thank you.
Thank you, Professor. A warm good evening to all gathered here for the 38th AKG Memorial Lecture organized by Jana Sanskriti. Ayat Kutiyari Gopalan, Comrade AKG, A.K. Gopalan, as a communist leader who has made relentless efforts to fight injustice and lay the foundations of an equal society. For this, he is adorned with the epithet, the value of the downtrodden. His autobiography, Ende Jeevitha Katha, is a testament to his trials and an attempt to trace the social transitions of his times with critical objectivity. His life and struggles continue to inspire many to remain committed to the values of equality and social justice. For Jan Samskriti, it is a matter of pride that we had excellent speakers and intellectuals in each edition of the AKG Memorial Lecture. Prasad already listed out the great speakers in the earlier editions. This year, in the 30th edition of the AKG Memorial Lecture, we are honored to be graced with the presence of Justice K. Chandru, speaking to us on the topic Constitution and Ambedkar on today's perspective. A topic of extreme relevance at a time when India celebrates the 75th anniversary of the adoption of the Constitution. However, in stark contradiction, the attack on the foundational values of the Indian Republic and our Constitution has become rampant, and the perpetrators of such violence enjoy impunity. Rapists are garlanded and those spewing communal venom are awarded parliamentary positions. In these times, we must strive towards developing an alternative that has its foundations in the constitutional values of democracy, secularism, and most importantly, the idea of equality. In this effort, Ambedkar and his ideas infuse us with the spirit to question injustice and inculcate the values of fraternity in its real essence or in our lives. We take this opportunity to also inform that Jansanskriti is planning to organize more such lectures and discussions centered around the Constitution and its significance this year, commemorating the 75th anniversary of the Constitution of India. We mark its beginning with today's lecture. I believe Justice K. Chandru and his words will help us gain more insights into the idea of the Constitution and the great contributions of Ambedkar in laying the foundation of democratic India. Prasad already detailed about Justice Chandru. He has been described as a rebel and fierce critic of certain practices in the judiciary. Contrary to the image that the legal profession suffers today, Justice Chandru was a man of modest means who dedicated his life to fight for the downtrodden. As a judge, he would ask lawyers not to address him as my lord in court as a customary. He did not want his arrival in court announced by a mace bearer, refused a personal security officer because he thought it had become more of a status symbol rather than being based on any actual threat perception, and declared his personal assets on his first and last day as a judge. You can read this with the recent news about a Delhi High Court judge recently 2 days back. In fact, upon retirement, he surrendered his official vehicle and took the local train back home. As a jurist, activist, and scholar, he believes that Marxism has helped him understand Ambedkar better. He is also the author of a book titled Listen to My Case When Women Approaches the Courts of Tamil Nadu, was published in 2021. This work traces the story of 20 courageous women and their interface with courts in Tamil Nadu. His other important work is Jai Bhim, My Judgment in the Light of Ambedkar, published in 2022, drawing on cases he heard during his years on the bench of Madras High Court from 2006 to 2014. It links instances of atrocity, discrimination in present-day India to the experiences of B.R. Ambedkar. Yes, we are aware Justice Chandru was the inspiration behind the famous film Jai Bhim, made around a legal case he fought in 1993 as a lawyer, emphasizing the atrocities inflicted on marginalized sections by state machinery. With this, I now invite our speaker, Justice K. Chandru, to deliver the 38th AKG Memorial Lecture on the topic Constitution and Ambedkar on today's perspective. Thank you so much.
Dear friends and comrades, I deem it a privilege to accept the 38th Memorial Lecture named after Comrade AKG. Comrade AKG, as you all know, one of the leading parliamentarians and a mass leader which the 20th century ever produced. I had an opportunity of interacting with him at least for 10 years, and most of our training in politics came from Comrade AKG. Therefore, I owe a lot of my political training with AKG. AKG, before I go to the paper, I have presented a paper, a long paper, which I don't want to read, you may get bored. Therefore, my intention is to highlight the theme of my paper. Before that, a few words about AKG. From 1927 to 47, he has seen, started with Gandhi, Congress, Socialist and Communist. That 20 years has seen him grown into a mass leader of Kerala, initially North Malabar, then the unified Kerala. From 47 to 77, his role from a parliamentarian and a constitutional, I would only put as a catalyst, and he's continued to fight to defend this constitution was something which we'll have to remember. So when the organizers wanted me to speak, I agreed to speak on the question of perspective of constitution and Ambedkar. On the contrary, the perspective that today I want to place before you is a perspective of the Marxist and the perspective of the Ambedkarists on the both sides, and then how from a point of disagreement, from a point of agreement, today we reached a stage where the Marxistas and Ambedkarists has to work to defend this constitution. That will be the theme of my speech. Before I go to the constitution, just before the constitution, you must realize that the Communist Party was most of the time under proscription by the British, except during the war efforts, because the anti-fascist war, there was certain cooperation given by them to the allies all over the world. In that sense, the communists were there in jail most of the time when the constitution making took place in this country. In 1946, when the interim government was formed, the British told them, we have a model for you. If you can't write a constitution for you, you can use this constitution. Then very, very correctly, our self-respect never allowed them to borrow such documents, so that India chose to write a constitution by itself. That itself is the first step from a Dominion republic to full independence. We have made it very clear that we will rule ourselves what may be the situation. It is in that sense, both Ambedkar and the communists were on two sides, but the Congress never had anything to do with these two groups. Ambedkar could not get elected to the Constituent Assembly. He came from the Bengal Assembly election, and after the partition, his term was also over. Therefore, Patel wrote to the Chief Minister of Bombay province to elect him. Ambedkar very jocularly said about this, when the Mahabharata was written by Vyas, he was a Dalit. When Ramayana was written by Valmiki, he was a BC. When they want to have an Indian constitution, they wanted a Mahar like Ambedkar. This is one of the very profound statement, because they could not find a person equal to Ambedkar. Though they boycotted him, he came to the assembly and became the chairman of the drafting committee. And then the next two and a half years in the assembly debates, you can see the wisdom, you can see the sharpness, you can see the intellect that Ambedkar posed in the assembly debates. Even a comma, full stop, a sentence, a word, there have been hundreds of hours of debate. You will be knowing at that time, Shankar drew a cartoon. Ambedkar sitting over a slide, and Pandit Nehru was trying to whip, saying why long the delay. Because 2.5 years for an independent country to have a document was something inordinate, and Nehru wanted to express the common man's impatience. And this cartoon made a point that the constitution making took quite some time. And then there are several reasons for that. One is the partition. Secondly, the Congress was not a unified force. Thirdly, they got to accommodate the princely states, which doesn't represent the common man. So this was something like a combination of several contradictory forces, which were led to a unified attempt to make a constitution. Now, this cartoon of 1949 suddenly found a place in the school textbook. Our 10th standard social science NCRT prescribed this cartoon. For what reason? Which teacher will explain the entire debate, the time that took for arriving at a consensus? Constitution is basically a consensus document. It is not by a majority. Time and again, Dr. Ambedkar has ever said there is never a majority. Even a minority has a role to play. And this is a document where it's a consensus, it's a compromise. It is something like an assurance to a minority, and therefore it took time. Now, suddenly, the NCRT books containing Shankar cartoon was misused because to show as if Ambedkar is delaying the preparation of the constitution. This is something, there was a lot of protests, more from Tamil Nadu, saying how you can denigrate Ambedkar like this. If you are very mature, you may understand the theme of the cartoon. But to tell a young mind of a 14-year-old boy, what is this cartoon? That Ambedkar is sitting on a snail and Pandit Nehru is trying to do the exercise. This is something, after the protest from Tamil Nadu, that cartoon has been removed from the textbook. Therefore, today, the happenings in the Constitutional Assembly continues to haunt several quarters. It is in that sense, the debates under the Constitutional Assembly is a very important landmark. In fact, the Constitutional Assembly debates are available in large, bulky volumes. Even when 42nd Amendment was made, in order to educate the parliamentarian, the Government of India published 5 volumes of the debates. The 5-volume debate, nobody purchased it, was lying down in the verandas of the stationery department. That was sold by 500 rupees at those days. But nobody ever goes behind the constitution. That's a major issue. What really went behind a sentence or behind an article, why articles are renumbered, nobody goes into this. Therefore, more than before, today, understanding the constitution in its real setting is more important. In fact, wherever Rahul Gandhi goes, he shows this book all over, saying this is the DNA of the Indian people. Now, how many are willing to buy this book? Recently, the Eastern Book Company of Lucknow, which published this book, very quite expensive, 800 rupees, said in one of the journals that 150,000 copies have been sold. So I'm glad just not the lawyers, not the law teachers, but even the common man is now willing to keep this rule book in his hand as an answer to persons who try to subvert the constitution. In fact, when Modi was trying to take the oath from the other side, Rahul Gandhi was showing this book, saying this is the book that you are taking oath under the constitution. Today, every judge, every minister, every parliamentarian has to take a oath that they will uphold the constitution without fear or favor, without ill will. Now, does that happen in this country? That's the most important thing. And therefore, the perspective in which this constitution was drafted is the most important lesson that we think of after 73 years of the working of this constitution. Now I will start. Where do we start? 1947, 15th August, we got the independence. The Union Jack came down, the Tirang went up, and the famous midnight speech of Pandit Nehru saying when the whole world is asleep, India will be awake to gain everything. Now this is a very inspiring speech. But what happened to the communists? They were in jail. For what reason? For sedition, for overthrowing a lawful government. Which lawful government? The British government. It was a shame that on the midnight of 15th August 1947, the communists were still languishing in jail. And Comrade AKG, writing on this, in my cell, I was looking for the day, because it was the midnight that was fixed for raising the flag. So he also prepared a flag for raising in the jail. And then they were never released. Though some of the communists were released, but AKG was not released. In his biography, In the Cause of People, is there in Malayalam, is there in Tamil, it's also in English, but out of stock. Very inspiring statement made by Comrade AKG. He says that what is that we have done? We have fought in every national movement. We fought in every disobedience movement. We fought with the Congress for the purpose of getting independence. Now on the day of independence we are inside. For what reason? 124A or the IPC for overthrowing the state. Which state everybody want to overthrow? The Independence Day is a culmination of the overthrow of the colonial rule that we had. And therefore he said, very unfortunate that we were stuck in the walls of the prison and then trying to see whether the new sun that is going to rise has any meaning for us. After a few days he was released in 47. Now that was a very troublesome period for the Communist Party because what is the new government? What interests they represent? Do they represent the interests of the common man? Do they represent the interests of the feudal and the princely or the capitalist, monopoly capitalist? And therefore in this formulation, there were also different viewpoints within the party. They did not accept this as a real liberation. They did not accept this as a break from a colonial past. And therefore there were also different methods to identify what will really bring a new life to the people of this country. In that sense, within the party, there are two lines of thought. One was an overthrow of this new regime. The other was to take a parliamentary path to work for the common good of the larger sense of the people, for a people's democratic method to evolve. Now, in this ideological fight in 1949 ended to a more progressive line where the communists took a parliamentary democracy. Now, that's a very important landmark. Communists accepted parliamentary democracy and worked within the legal framework. In 1949, when the final draft of the constitution was introduced to the Constituent Assembly, namely on 26 November 1949, which is now celebrated as a Constitution Day by the government, Law Day by the lawyers. Now this 26/11/1949 is a day on which this draft was accepted by the entire House. Now the historic speech which Dr. Ambedkar made on that occasion is most important because he is now trying to explain how this document was evolved. Now this document was evolved by the members discussing. There is a drafting committee, there are constitutional advisors, there are several other efforts were taken to see all over the world. Some judge from the Madras High Court said it's only a copy, it's only a replica of Government of India Act of 1935. There's nothing new. It's only a perverted mind, a High Court judge to say like this. But if you read the Constitution and see the 1935 Government of India Act, there may be some similarities. For example, there can be legislature, provincial house, there can be parliament, there can be Supreme Court. There was no Supreme Court, there was only federal court. There was the high courts. All that can be there. That is there in every constitution all over the world. But what is important today is the fundamental rights under the Part 3 of the Constitution. It is the directive principles under Part 4 of the Constitution. These are the crucial provisions that have been added, which made more flesh and blood into a skeleton that is the 1935 Government of India. Dr. Ambedkar, when he addressed the House, he said two things, important things. First thing he said was, why is that the socialists are not here? Why is that the communists are not here? They were not elected, they were not there, that's a different issue. But he gave a reason. He said that the communists do not believe in the democracy. He also said that the socialists don't believe and they want all state enterprise and all enterprise to be nationalized. Therefore, they are not participating in this constitution and therefore they are not here. But whoever is available with him at that occasion, he was able to do a job. And you know, Ambedkar himself is a socialist. He strongly believed in a state enterprise. He also participated in many trade union battles in Bombay. His own party was a Labour Party. And therefore, there is no doubt that Ambedkar never supported a capitalist method of economy, and therefore that is writ large into the constitution. If you see the constitution, especially the part 4, many people used to say, why part 4? Not an enforceable motion. It's only a platitude. It's only a state policy. But nonetheless, it shall be governance in the country, and Parliament shall make law to the extent possible. This is something very important addition, and it is completely, if you see the constitutional frame, the absence of the socialists, the absence of the communists were made good by Ambedkar. And therefore, when he mentioned that they were absent, he was indirectly trying to say, in spite of their absence, I was able to make a document like this. It is a completely a socialist document, which if you read carefully, and therefore, when they started with the constitution, the communists were not there in the creation. And Dr. Ambedkar, true to his moorings, true to his economic philosophy and social thinking, he was able to make a document in a country, in a house which is not a representative body, which 13% voted in the election, not the entire vote rate. Everybody is not allowed to vote. And then he was able to make a document of this nature, and therefore that talks about the greatness of it. This is the 1949. Now when the communists have come out, they have decided to participate in the election, and the first election was in 1952, and constitution already come into force in 1950. Now the elections are waiting in the general election in 1952 for so many reasons of electoral roads to be made ready, and so several other issues are there, because first time we are having an adult franchise at the age of 21, and therefore the communists who were out were again put back in jail, and A.K. Gopalan was detained under the Preventive Detention Act, and when he was in jail, the constitution was available. The first lesson was, you are guaranteeing liberty. If you say there is a liberty is guaranteed, why is that I am in jail now? Under which law? A detention law is made by the British. A detention law where there is no trial. A detention law where there is no charges. And therefore he challenged. So the first constitutional challenge came from A.K. Gopalan. That is how the A.K. Gopalan enters to the constitutional fray. And Ambedkar were very much alive. He was there to see all this constitution. After his detention, which was challenged in the Supreme Court, newly created Supreme Court, the argument was that if I am allowed to move out throughout the territory of India under Article 19(1), where you can say a citizen can move throughout the territory of India, he has the right to expression, he has the right to form association, then where is the question of putting me in one jail and then say you are here because the district collector or the district magistrate wants you to be there. Now this was a very embarrassing situation for the court, and this case was argued by M.K. Nambiar, the father of A.K. Gopal. He came from Madras to argue this case. So it was a new lesson for the Supreme Court judges, because for the first time they are testing a law in the light of the Constitution. Because the Constitution says under Article 13 that no law made before or afterwards will be valid unless it is subject to the confines of fundamental right. Now the fundamental rights are several. Article 21 is one right, Article 19 is another right. Now how do you correlate these two related? Now this is the issue before the Supreme Court. And Supreme Court didn't want to release the communists because they were the judges of the Congress. I am not saying there is a party bias. They generally wanted to support a new government. And therefore, in order to justify A.K. Gopalan's detention, they invented a new theory that our constitution is different from the American constitution. You cannot go into the validity of law, which law decides you to put inside. The Preventive Detention Act, made by the Parliament, prescribes a procedure. Since the procedure has been followed, there is no question of challenge. They dismiss the case. The first constitutional battle to bring the constitutional value into practice was a failure. This Ambedkar knew very well for his own knowledge. The second constitutional case, that also came from the United Madras Presidency state. All the first three constitutional cases came from South only. That means the southern people have more faith in the Constitution. I am emphasizing this because none of the constitutional challenges cases came from the north, it came from the south. The second case came from Mr. V.G. Rao, who was my senior in my profession. I had worked with him, a leading barrister. He was the son of a High Court judge also. He was a leading barrister. He went to do ICS in Britain, but he joined the party, and then just to explain to the parents, he became a barrister. When he came back, he started a practice. At that time, when the Communist Party was under ban, he started a small society, People's Educational Society, which had a small bank account. The idea was to educate the people the true constitutional spirit behind the Constitution. Now, his association was banned, not under any new law, by the old 1908 Criminal Law Amendment Act, which prohibits unlawful association. What is unlawful association? Nobody knew. The British never wanted that to be defined at all, because for them, every association which demands independence is an unlawful association. Now the Congress government wanted to invoke 1908 Act and declared People's Education Society as unlawful association. The bank account was frozen. He was a leading barrister in Madras High Court, and then his association is declared as unlawful association. What kind of face that he had? And he is also a constitutional specialist. Therefore, he saw the Constitution. When you say that you can form an association is a fundamental right, how that my association is bad? What is this unlawfulness? This is most important. And that too under the 1908 Act. 1908 Act is notorious for two reasons. When the British made this law, they brought two Criminal Law Amendment Act of 1908. Criminal Law Amendment Act 1, Criminal Law Amendment Act 2. Then they brought in 1911 a Prevention of Seditious Meeting Act, that you cannot have a meeting which is seditious nature. These three were considered to be a black law, and Mahatma Gandhi declared non-cooperation movement, that as long as these three laws are in statute book, we will not cooperate with the government. And this non-cooperation movement led to the appointment of a Rowlatt committee. Rowlatt was a British judge who found all the three laws are very good. Therefore, these laws are called the Rowlatt laws. Now, these Rowlatt laws were revived by the Congress, and then V.G. Rao's association was banned. He moved the Madras High Court successfully, and the case came from Madras to Supreme Court. State of Madras was V.G. Rao. The second constitutional case, which established right to form an association, is a fundamental right. Now, this is something. The first case was a communist, which is a failure. Second case was by a communist, which was a success. Where to say whether the fundamental rights are active, whether it could be enforced by court, is something that is proved. There was also a third case, Champakam Dorarajan case. She was a lady who never applied for any medical seat. Madras City, Madras State had a communal GO, where every post in the government will be given to on a 6 ratio basis. 1 will go to Brahmin, 2 will go to non-Brahmin, 1 will go to Indian Christian, then the 1 will go to the scheduled caste. So all 6, it is a communal GO, which has been there in 1920 onwards. Now, she filed an application before the High Court saying, I want to go to medical college. By this method, I will not get, merit will be the casualty. Now, merit is a casualty, then Article 15 talks about non-discrimination on grounds of caste. How do you have seats reserved only based on caste? Now, Madras High Court promptly struck down the communal GO, which was in force for more than 30 years. And that led to a larger protest, and Nehru didn't know what to do. He consulted Ambedkar, who was a minister. The first constitutional amendment was necessary to get over Champakam Dorarajan case. Does it mean that we cannot have a affirmative action through court action? Does it mean Article 15 and 16 become meaningless? Therefore, Ambedkar suggested, instead of caste, it will be socially and educationally backward classes. The word SEBC was now introduced in the place of caste. Now, does it mean caste is not a basis? That's a different debate. But what is now to save the reservation? The SEBC amendment was brought in by Ambedkar. This I am emphasizing, though it may look more legal, but I want to tell you the first 3 constitutional challenges to the Constitution, Ambedkar was a witness, was the author or the person who drafted, he himself knew what's happening to his own constitution. It is in that sense I feel that he was able to bring certain amendment to make it appear it is not a scripture, it is not a holy book. Time requires, when the people's aspiration wants, it can be amended. It has been now amended up to 103 times. The 106th bill is still pending. The women reservation still pending there. But it is not a document which can never be tampered with. It is not a document which can never be amended or changed. It is not a holy book. Therefore, the amendments that is made to the Constitution had made the Constitution to make a living document. It is in that sense more important. And after these three exercises of the challenge to the Constitution, if you see the role of the communists, because the communists are the maximum made use of the Constitution code to make it appear, is there a justice in this under this Constitution? Now, the first elections in 52, A.K. Gopalan got elected, and from then onwards he never was defeated. 5 times he was a member of parliament, 52 to 77. He continued to be the member of parliament. He was also opposition leader, and therefore most of the debates in the parliament, he had a function to, he had a role to participate in that. And Kerala again became another standing example how far this constitution as a living document was able to help the larger public question. The first question came in the 1952. In the Madras state, the Congress party could not get a simple majority, similar to our Modi government. Today it doesn't have a majority in the party. Thanks to Chandru Naidu and Nitish Kumar is continuing as a minority. Though their slogan was 400 Bs, Aapki Bar 400 Bs, but then they gave it only Chako Bar. I am not saying Chakabar as a joke, because in Madras, when Modi came, there was an open jeep procession. So one BJP enthusiast said, Aapki Bar. There were a lot of ice cream shops. People didn't know what is 400 Bar, because the Hindi is not very familiar. So they all started shouting Chako Bar. For 15 minutes they were shouting only Chako Bar. And finally people gave him only Chako Bar. We must thank Kerala, Tamil Nadu people for giving him Chako Bar and not an absolute majority. That is another facet of democracy, and I will emphasize this issue that when the first time in Madras presidency, they did not get a majority, and the Communists were the second largest party. There was a possibility that Communists could stake the government, and in order to avoid that, Mr. Raja Gopalachari, who is known as Rajaji, was made as the chief minister. He was not an MLA, he was not an MLC. Nehru said, we'll make Rajaji and then he will maneuver. How did he maneuver? He called two caste parties. One is the Commonwealth Party, the other was the Toilers Welfare Party, Ramaswamy Padayachi and Manikavel Nayakar. Each had some 20 seats and then made them as part of the government. And then, how will he become the chief minister unless he is an MLA or MLC? Governor nominated him as MLC. Even before the house could be constituted, he was declared as MLC. Now, so many fraud took place on the first election in the Madras presidency. And then P. Ramamurthy challenged, he was the leader of the opposition, leader of the Communist Party. He challenged this in the Madras High Court. And Chief Justice Rajamannar rejected it by saying, Ramamurthy has no locus standi. The locus standi today must have grown much wider. Even a common man can file a case. Those days, the leader of the opposition could not file a case. It was dismissed. There were many open-end questions in those days, and the constitution never, or the judges never found an answer. You must know one thing, it is not what is written in the constitution, it is what the judges say. And therefore, every time when the judge says something, it becomes part of the constitutional frame or interpretation. Now, the same A.K. Gopalan case was disagreed later in 1967, when Indira Gandhi nationalized 14 banks. That was struck down by the Supreme Court, saying the compensation is not enough. Now, in saying that, for them the A.K. Gopalan case standing as an obstacle, and therefore what did they say? A.K. Gopalan is wrong, because they had to decide in favor of Tatas and Birlas in the banks which has to be denationalized. Now later Indira Gandhi brought an amendment We could see it later. But what I am saying, what was said in A.K. Gopalan, after some 17 years, it has been disagreed. Similar thing happened. What is said in Chappagam Dorraju was disagreed by the Supreme Court in Golokka. This I am emphasizing to say, within the Supreme Court, there has always been two streams of thought. Supreme Court never works as one body. It works in smaller benches. The thinking process can change depending on the benches. And therefore, from day one, from 1950 till now, the court had produced judgments of both sides. So it becomes a lawyer's paradise. In fact, this is one of the issues where we should think that the Supreme Court, being the court of the highest order to interpret the Constitution, can also write in both ways. And therefore, our fight is not just the executive, it is not just the parliament, it is also the Supreme Court to see what is the true spirit of the Constitution, to what extent they have upheld the Constitution. This is most important. And each time when such questions came, P. Ramamurthy case was dismissed on the ground of locus standi. What is the locus standi? The principle that party which has got the largest MLAs will have to be invited, but that is not the same. And Rajaji became a chief minister through backdoor. Of course, the party's squabble was so strong. In 1954, he has to resign and go away, and Kamaraj became a chief minister of Tamil Nadu. But most important issue, in 1956, when the states were reorganized on linguistic basis, Kerala became IK Kerala. The Travancore, Cochin, Malabar all became into IK Kerala. And the first elections held in 1956. And to the shock of the Congress, the left government was to be formed. The left parties won the election. For the first time world over, the left parties were able to prove that in participating in a parliamentary democracy, they were able to capture the power of the state. Maybe a smaller state, but then nevertheless, it was a significant victory, which is a news which spread all over the world. For the first time, a left party, a communist party is able to win a parliamentary election. It is in that sense very important election. In 1956, when EMS became the chief minister and Krishna Iyer was the law minister as well as the home minister. Now, 56, the government came in. The first bill which they were working on is the Kerala Education Bill. The mushrooming growth of private education institutions. They want to control, they want to regulate, and also to provide teachers that will come out of conditions of service. These are the very important issue. Now, when this bill was brought in, all the forces joined together, whether the church or the Muslims or the Nair Service Society or the SNDP, all of them came together and started an agitation, which is called Vimojana Samar. Very ironically, from whom they were trying to liberate, we do not know. The Vimojana Samar was also blessed by the Congress, and Indira Gandhi was the first time minister, was sent to Kerala. Then the governor, without a governor's report, the government was dismissed on the ground. They were unable to carry the constitutional functioning of the government. First time an elected government was dismissed in 1959. When that government was dismissed, what happened to the bill? The bill was not challenged. On the other hand, President referred to the President's opinion. The President's opinion to find out whether it's constitutionally valid or not. Finally, the Supreme Court held the bill is valid. The bill became valid, whereas the government lost power. That's the kind of situation that we had. And when an elected government is dismissed, do you have a judicial review? Can the President or anybody else move the court and say a valid government has been dismissed for no reason? Now, this was an issue which was raised at time but could not find any answer, and EMS went out of power. Now, this is the first assault against the Constitution and against the elected government. Therefore, you should also see within this Constitution you have certain negative features which could be used, and one of the features they found, there is no judicial review. Today, that is not the situation. In 1994, in Bombay case, they said judicial review is possible. Today, it's not possible for Modi and Shah to dismiss government because it has to be approved by the parliament, and then judicial review is still available. And Uttarakhand government was restored notwithstanding the dismissal by the governor. Now this is something which is very important. Every time, even judges also learn the legal provisions for the first time. What was wrong in 50, A.K. Gopal was right in 67. What was wrong in Champakam Rajan in 50 was right in 1991 in Gorakhnath case. Now that this trend that you see is a parallel trend. One for a true democracy, other one for a limited democracy. In that sense, when EMS lost the power, second time elections came, 1967, Congress lost in 8 states, including Kerala, and EMS became a chief minister and left-front government. Now EMS in one of the press conference in the Trivandrum, the press asked him, what do you say about the judiciary? He said, judiciary is always subservient to the economic system. The judges can never rise above the economic system. This is a very correct Marxian stand on judiciary. You may participate in government. You may say there is a judiciary, but whether the judiciary can rise above the economic system is an issue which is purely a Marxist theoretical stand. Now somebody filed a case. You are denigrated the court. You have committed contempt, and therefore the contempt case was heard by the Kerala High Court and punished EMS Ambedkar. They fined 1,000 rupees fine. A sitting chief minister was fined by the Supreme Court, by the Kerala High Court, 1,000 rupees fine. He filed an appeal, and V.K. Krishnan appeared in that case. And when it came to the Supreme Court, they were willing to reduce the fine, but not cancel the fine. Because at that time, the chief minister's salary is 450 rupees. 1,000 rupees means 2.5 months salary he has to pay. And he was cycling to the assembly. And therefore they thought, he's a very poor man, reduce the fine to 50 rupees. But what is most important was, they wrote in the order that EMS does not know Marxism. This is most important. A world-renowned theoretician who is a Marxist exponent, the Supreme Court writes in his order that he does not know Marxism. It's very shocking. In fact, later in the People's Democracy, Basavapanya wrote an article. It is the Supreme Court judges who do not know Marxism because the quotes that they made in the judgment are all secondary, not from the original text. And he has shown from the economic and philosophical manuscript where this formulation can be made. There is nothing wrong in it. Therefore, this debate was given up. Whether the judiciary can subserve the economic interest or it can stand above the economic interests of the society is something which you can see later what happened in this case. In 1967, when Indira Gandhi was finding minority within the Congress party, she led to breaking the party. In 69, Congress became two factions, Indicate and Syndicate. Now she wanted to get master support to go to the parliament. 71 elections were still on the corner. Therefore, she nationalized all the 14 banks which are owned by Tatas and Birlas and so many monopoly houses. Now, when the bank nationalization was challenged in the Supreme Court, Supreme Court said the compensation that you offer is not enough and therefore is struck down. They take the money from the people, they reinvest in the trade and they make more money. And the Supreme Court wanted the government to give compensation to these bank owners. Bank was used by them to siphon off funds, which is a public fund. And now the court said the opposite. They struck down. Now it required a change in the constitution. Therefore, the first constitutional amendment, that the 24th constitutional amendment, was brought in. Then the erstwhile deposed princes were also getting pension after the independence as something reward for the notorious service they were doing as a princess. Now the privy purse was abolished. Now that was again challenged. Supreme Court said no, you can't abolish. It's a solemn promise. Now these two judgments, the basis of this judgment was to get over. Therefore, two amendments were brought in, 24th Amendment and 25th Amendment. And these debates in 1972 constitute the first constitutional thinking in our country. Till such time, for 20 years, the debate was not taken to such level. And you should see the argument put forth by A.K. Gopalan, argument put forth by P. Ramamurthy in the parliament, page after page, defending what is the true spirit of the constitution. In fact, in 1972, A.K. Gopalan moved a constitutional amendment bill along with Dasarath Dev from Tripura. You will be very interested to know the three formulations of AKG amendment was the governor must be asked to give assent to all the bill. Second was the governor must be appointment must be approved by the state legislature. This is the second one. The third issue that they were raising in another constitutional amendment was voting age should be reduced to 18. That was the Sabar Mukherjee amendment. Now the first two amendments, it was introduced as a private bill. If you think backwards now, if those amendments have been carried out, you would not be facing Arif Muhammad Khan, you would not be facing R.N. Ravi, because the federal structure was put to strain by a unified party ruling a center, and therefore to check on the federal incursion, the federal aggression. These two amendments are moved by A.K. Gopalan in his personal name as a private member. The arguments on 24th and 25th amendment brought in the wider debate: is the judiciary subserve the interests of the common man? This was the issue that was raised during the page after page. People have criticized the judiciary in the house and even outside, saying judges don't take an oath under the constitution. They are not subscribing themselves to the oath of office. Now this is something which you have to keep in mind. Now the 24th, 25th amendment, which was subsequently challenged, was upheld, and Article 31, providing property as a fundamental right, was removed, and for the first time, certain socio-economic legislations were able to be pass the muster during the Supreme Court's scrutiny. Now then came the 76-75 emergency. Within a short period, Indira Gandhi thought she is the Queen of India, and therefore declared a national emergency just to save her from being deposed from power, because the opposition was coming together. Now during the emergency, an attempt was made to change the constitution extensively. That's why I told you the parliament, the stationery printing house printed thousands of copies of Constituent Assembly debate. I don't know how many members will read the entire debate, turning into some 5,000, 6,000 pages of comma, full stop, words. Very fascinating document for any legal mind. Now, when this method was started, the attempt to change the constitution extensively, and there was a 44th constitutional amendment bill was pending. All the party leaders convened a meeting in Delhi. They issued a joint statement. On behalf of the CPM, P. Ramamurthy, A.K. Gopalan, and E.M.S. Ambedkar signed that statement. One of the significant statement was, today's constitution do not suffer from any infirmities. With the amendments that have been made, it is enough to pass any legislation in favor of the poor and for socio-economic development. We do not subscribe to change this constitution. All these amendments are intended to protect your own personal political right, which will lead to in the larger run, it will lead to a dictatorship government in this country. And they have opposed it. They opposed it at a time when censorship was in order. Their statement will not come in the press. Their statement came only in the People's Democracy, which is a CPM organ. Their statement will not come because there is a pre-censorship. Fundamental rights were suspended. For the first time, people thought that the constitution can be subverted by a small coterie. In fact, the subsequent Shaw Commission inquiry found when Indira Gandhi recommended the imposition of President rule, he did not have any cabinet resolution, and the Fakhruddin Ahmad, who was the president, did not even ask where is the cabinet resolution. A letter was sent from a relative, and then at that time Abu Abraham, a famous cartoonist, published a cartoon in the Indian Express. It showed that the president was in a bathtub, and the door will be little open, and president secretary asked him through the open door, sir, he'll ask the secretary, any more bill to be signed. So they were hunting for Abu Abraham to be arrested and put in jail because of the cartoon. Thanks to the international vigilance, he was escaped, and subsequent to Janata Party power, he was nominated to the Rajya Sabha also. One of the brilliant cartoons that you could ever think of those days. And now the emergency, the 42nd Amendment came in, extensively amending the Constitution. Even you cannot go into the election of Prime Minister or President. And subsequently, it has been dropped. There is a 44th Amendment which removes some of these things. But most important issue is, in these 26 years, up to this 42nd Amendment, you must see Comrade AKG's role in defending this Constitution, in suggesting methods that will bring larger good, in questioning the operation of the Constitution in a particular point. It is in that sense the communists, especially led by AKG, played a very positive role in defending this Constitution, expanding the horizon of the Constitution, in also fighting for a larger social right. And therefore, in this, from 1952 to 77, 5 terms in the parliament, he has played a very significant role, and the role not just as an individual, but as a larger body, as a left thinking in this country, which supported the Constitution. Though Ambedkar was not there at the time, but by the time the Constitution started slowly standing on its own leg. But most important issue is after the 42nd Amendment, the loose Janata Party network wanted to remove some of these provisions, so they brought the 44th Amendment. Now the 44th Amendment did not remove every 42nd Amendment. Therefore, they did not remove all that has been done during emergency period, either they were wantedly or unwantedly. But one significant amendment that was brought in is amending the preamble to the Constitution. Now it's no longer a Constitution where there is a sovereign democratic republic, but it is a sovereign socialist secular democratic republic. Now these two words were introduced into the preamble. What is the significance of the preamble? Supreme Court says it will become a basic structure of the country. You go to the room, you need not enter the room. You can see through the keyhole what is happening inside. So a preamble is a keyhole, and the keyhole says there will be socialist and secular. Now, do they really introduce new document? In fact, time and again every jurist have said that already this constitution is only a socialist constitution. And secularism is writ large in the constitution. If you see Article 25, if you see Article 26, is that it gives every citizen, not every group, a right to profess, right to believe, right to propagate a religion. Now, therefore, these are not the words. In fact, Supreme Court said that these are not something added which to be removed. It can be cut off. Later there was a challenge. Subramania Swamy, as usual, filed cases. 2 months before, he filed a case that secularism and socialism should be removed. Supreme Court rejected it by after 46 years. It has become part of the Constitution, that we will not touch this. Now this remains as a slogan. Now this is a keyhole. This is a basic structure. In fact, Kerala government, thanks to Pinarayi and the constitutional awareness, now today every school children in Kerala is given the first page of the Constitution. Now why should it start? Now the idea is to start from the youngest mind. You must know this is the constitutional value. That we have a constitution and the value is there in the preamble page. And now the first page is given to every children in Kerala. I think every state should emulate this, because the constitutional values have to be fed into the minds of the young. This is more important. That's the only rule book that we have. When great states are there, when the country is played by different political groups, now what is the rule book? This is the only rule book. Now this rule book is not taught to our children. Then where will they ever have an idea? In fact, I can give you a small episode. When Australia and England were fighting a World Test cricket match, the match ended in a draw. Now in our country, everybody must have one winner and one vanquish. We can never have a draw. Therefore, they were looking for a new rule. They found out we can give a penalty over, so they gave another over. Even the results became draw. And nobody wanted to accept a draw. Everybody must have a winner. So the umpire met and found out not a rule, some precedent, some British precedent, which is always doubtful precedent. They said whichever the team which got maximum 4s and 6, that will be the winner. Now the England declared as a winner. Now the match is over. The match was over at 1 o'clock in the morning. Afterwards, our youngsters were Googling through Google search machine to find out whether any such rule exists or not. There were 44,000 hits on that night between 1 o'clock and 3 o'clock. If our children can burn midnight oil to find out in a worthless game, was there a rule? When a country is played with a huge rule book, nobody is ever even discussed, no school ever discussed, no college ever discussed, no one ever discussed whether this rule is valid or not. If 370 is removed, that's all. Kashmir should have a special status, no special status. Nobody ever discussed. Therefore, when Rahul Gandhi takes this book everywhere, the significance that it says that it is a DNA of our Indians is something which we have to take it seriously. It is in that sense every constitutional debate. Now you take the debate of secularism. Now our governor Ravi says, I have gone through the constitution. Now where secularism defined? You think constitution is a dictionary? Constitution is interpreted by court. A 9-judge bench in Bombay case says secularism means all religion will be treated equally. It is not like the Western that we are divorced from state. State is divorced from religion. It is treating all religion equally. Now this is an interpretation given. But a governor says, who is a former IPS officer, who now says that secularism is not default. It's all catchword. Now this is something which is we'll have to now think. What is the significance of secularism? It gives us an opportunity to discuss what is secularism. Now we have different interpretation. Now the Supreme Court has settled what is secularism. Now do we find the answer in Ram Janmabhoomi case? In the Ram Mandir temple case, is an answer given in the form of secularism? They write something, majority faith has proved unbroken rule of 500 years of worship, and therefore you give in a platter. What about demolition of the Babri Masjid? You say that the agrarious error, just see the agrarious error is enough. In the same site you build a temple, and what is the message that you are running? Is our country run on the line of secularism, which is a preamble, which is a basic structure? You take socialism. Now socialism, we do not, if you see the Supreme Court judgment, they make it like a laughing stock, as if it's a dirty word. In fact, one judge writes, it becomes a catchword. Another judge writes, socialism means different thing to different people. And then what follows? We should follow liberalization, globalization, privatization. Who says all this? Not the finance minister, not Manmohan Singh, not Nirmala Sitharaman. Judges are saying, what is the result of liberalization? We get pubs in the airport. I am not saying from my mouth, I am saying from a Supreme Court judgment, which says, today we have pubs in all the airport. People love to believe all this liberalization. So you have pubs. Then when Maharashtra government said no women bartender, that law was struck down. And Maharashtra government said no women dancers, that was struck down. Therefore what it means, we have a pub, we have a dancing girls, we have women bartenders, this is what you are talking about, liberalization. What about education? What about money for education? You give a different interpretation. What do you say? The Article 21A only says to provide means they should provide, not finance. It can be done by private parties. What in DMFI says, you can start an education institution like any other investment and they are entitled to get reasonable return. Who decides reasonable return? Your fee fixation committees. If the fee fixation committee is not enough, Supreme Court will say, this is the fee that you will have to pay. Now what? We have gone through a new phase of our own governance, constitutional governance. It is in that sense what Ambedkar envisioned on the 26th November 1949. He not only talked about the socialists and communists are absent, he also said, today we have reached a political independence, but the economic independence and social emancipation is still yet to be done. The sooner we do the good for this country, otherwise this constitution will be shredded into pieces. This is the very same statement made in 1949. Today we have reached a stage where every portion of the constitution, every value of the constitution, in fact they have invented a new word, constitutional morality. Now constitutional morality is lacking in the constitutional interpretation of India. It is in that sense the perspective today that we talk about Ambedkar, and also the Marxists on the other side, they have now started on a same common denominator. The common denominator is there must be a federal structure for this country. There must be social justice written to large. There must be secularism. There must be socialist economic policies. Now this is something which is very important because today when there is a privatization, when they deconstruct a public sector, when they privatize, when they sell the shares, now there is no judicial review. Supreme Court says it's a policy matter. Now what about your socialist preamble? No, that's all catchword. It's withering away. This sentence you can say in my paper, I have quoted from various gentlemen, how they look at the socialism. And they look at the socialism in a different way. For them, socialism is a catchword. And it withers away also. Now when Achyutanandan government wanted to take over Tata Teas, Tata ran away. They didn't want to run the tea because they were no longer profitable. They formed Kannan Devan Tea Estate. That was struck down by the Supreme Court. You have no power. When the Thiruvananthapuram airport, Adani's to take over the airport, Kerala government said, I will run. It's not very difficult to run an airport. Just be there with the government land. Supreme Court says, sorry, you are late, we are not interfering. Now every progressive step by a progressive government is put a check, not in the name of the Constitution. Now does the Constitution mean the same? That's the issue. Therefore, you just recall. If you have a different trend, if you say Ekakapalan, no release, and then say Ekakapalan judgment is wrong. If you say Champakam Dhararajan communal jiva is bad, then you say later Champakam Dhararajan is wrongly decided. If you say that Kerala government can be dismissed, now you say in Bombay case is judicially review is possible. Now, is the Supreme Court speaks in the same voice. That's the Supreme Court. I come to the end by saying the part 4 of the Constitution, one of the crucial provisions is 39B, where in the Socialist Charter, Ambedkar added that all the resources, material resources of the community, all the material resources of the community shall be distributed in such a way that will bring common good. Now this is something, policy. Now Justice Krishna says that material resource means not just the state resources, it's the resources of including private resources. He says the same thing. When Chennappa Reddy, another leftist thinker, he says in the Sanjeev Kohl case that it means common property. Now these two judges are targeted for attack. The 39B comes back to a 9-judge bench. Krishna was a 3-judge bench. Chennappa Reddy was a 7-judge bench. But now it's 9 judges bench. They want to say the first day of the hearing, the Chief Justice of India tells the Solicitor General, Mr. Solicitor General, we will not accept the Marxian interpretation of Krishna. Whereas Krishna was never a Marxist. He was an independent supported by communists, that's all. And he had taken several decisions on his own. But then the Chief Justice of India gives a warning on the day 1 that we will not accept the Marxist interpretation. What is the Marxist interpretation? If you see 39B, does it evolve any other method of understanding all material resources? It means only government resource or a public resource. Any dictionary meaning will give you a different idea. But then the Chief Justice finally writing a judgment for the majority. There were only 2 dissent. The 7 agreed with him. That is the trend of liberalization. Now what they say, we will not include private property. Only the state can distribute its own resources. That's all. You may say whatever you want because it's a prerogative to say whatever, even your sneeze, your cough can be binding judgment under Article 141. You may say anything. But then they attack Krishna saying it is a Krishna and Chennappa Reddy's interpretation that led to the wrong path of this country. How does it become the wrong path? How does some judgment become the wrong path and your judgment becomes the right path? This is something which is something very important. And one judge who had the guts, Mr. Justice Sudhanshu Dolia from Bengal, he said, Mr. Don't denigrate Krishna and Chennappa. That we have a constituency, that is a constitution. We have a manifesto, that is a constitutional morality. How do you justify somebody saying, no, they are wrong, a leftist ideology is wrong? Now this is where we stand. When we talk about the perspective, we come back to square one. Today, what is the perspective of this constitution? Where does Ambedkar stand? Where the Marxists stand? They stand on the same footing, same common denominator. Whether it is a question of economic policy, whether it is a question of secular policy, whether it is a question of federal structure of the constitution, they stand on the same footing. When AKG said that we must have elected governor, that's a check on the aggressiveness of the center that we have seen in the entire four southern states, Tamil side or our Mohammed Khan or Ravi or anybody for that matter. They were playing a game set by the Home Ministry, and then they tried to destabilize the government instead of a center to support all the state government. Today there was a meeting in Tamil Nadu. What is the resolution passed? Then you can't bring in delimitation to the disadvantage of the southern people because they adopted some scientific planning methods in family structures. They found that this is something a call of a federal nation, that you can't have a policy where you make it a unitary state. Even your slogan, one election, one nation, is a thing which is still a debatable thing. There are supporters, there are opposers, but then quite rightly, most of the opposition ruled parties have taken a stand. It is a very wrong stand. No, this is the constitution has to be worked in a particular manner, where it becomes more and more a centralized force, leading to one nation and one leader. That is quite possible. Or the other way around, that it is a federal structure where the federating unit have their own autonomy. Even Kerala has to file a suit in Supreme Court to get money to be released for them. The Tamil Nadu government is openly said, unless you toe our line, we will not release a fund. Are we all vassal state? Are we all state which are just subordinate to this center? This is an issue which keeps coming again and again. And therefore the time has come when the Marxwadi or Ambedkarwadi has to stand united to defend this constitution so that the basic principle of federalism, secularism, socialism is upheld in this country. Thank you.
Thank you so much for a wonderful speech. Now we have a small session of interaction. Please raise the question, straightforward questions, not statements, please.
Sir, sir, thanks for the good speech. Can I, sir?
No, you can speak. It's being noted down. It's getting noted down.
In your speech, you mentioned about the EMS thing. EMS fine 1,000 rupees. It's not in a function. It's a press meet at Toronto, and he mentioned that two persons came in front of judge. One man with good dress and fatty man, rich man, and a poor man. Judge always comes along with rich man, and the rest is correct. In Supreme Court, he paid 50 rupees fine. And second thing, you mentioned about one cartoon on Abu Abraham. Abu Abraham appointed Rajya Sabha member in the time of Congress government, not Janata government. 72 he appointed as Rajya Sabha. He drew that cartoon while he was in his army.
So good evening. Yeah. The reason was the last
one decade, we are witnessing a severe attack on the constitution by the rulers, by the ruling party in India. So what exactly troubles the ruling political class in the present India? In the constitution. Why their political ideology? What troubles them in the existing constitution? And how is conflicting with their political ideology, the present constitution and their political ideology?
Hi sir, very good evening. My name is Donald. My question precisely is when you mentioned about the term, how is the state of economics fundamentally is not something judiciary, let's say, can adjudicate beyond an extent. So my question is, how much money and manpower is impacting judiciary in the present day context with regard to the recent thing that happened at the Delhi High Court, where a judge was now shifted over to the Allahabad High Court on the basis of unaccounted money. So my question is essentially, how is judiciary getting impacted by other types of financial implications and the pressure that people are facing over?
So just one thing, we have been talking about the federal system and what we have been witnessing in Kerala during the time of the great Muhammad Arif Khan. So, and that's the same thing has been happening to the other southern states. What should be the remedy? How can the constitution help them? One is that. And second thing, also this something called the anti-conversion bill, which is, or the rules which are made in different states. When we call ourselves as a secular country, and particularly in Madhya Pradesh recently we have been hearing that even the thinking of capital punishment and things like that. So what should be people like us to do, or what is the remedy?
So recently there was a news in which Allahabad High Court ruled that grabbing the breasts of a girl or snapping out the pajama of a girl is not an attempt to rape. But how is that justifiable? I have heard my friends talking like they don't have any. They don't believe in judiciary anymore because of all of this. So how is judiciary justifiable for such rulings they give out? That's my question.
Last question. See, nowadays what we see is, you correctly pointed to Article 370, whether it is another judgment, okay, judgment, whatever it is. Generally what we see is court is keeping mum on many controversial issues. What would be the reason? You can say the cases of Rajan Gowai, etc. We have seen. But exactly, even now the court, the entire judiciary is gradually becoming a puppet in the hands of the ruling regime. If I say so, will it be right?
I will start with the Allahabad judgment he is commenting, because that is now being going in the bigger in the social media. Every judgment, unless you read the full judgment, you may not be able to understand what the judge actually saying. Now the judge was dealing with a case where somebody filed a case that this would not amount to rape. When they challenged that the trial court should not frame the rape charge, which is under 376, they were only concentrating what constitutes rape and what does not constitute rape. It doesn't mean they are going to let out the accused for other offences. Now, pressing the breast or opening the pajama that would not amount to rape, may be a correct position of law in terms of rape section. But then he will be tried for other sections also. Now when the judgment comes, the social media immediately reacts saying, this is what the judge said, it would not amount to rape. Any person who is familiar with criminal law will know what is rape and how the law prescribes the rape. Now when the judge says the same thing, but in a government context, now everybody is attacking the Allahabad judge. Now he only said you cannot add the rape section, you can add other sections. There are 101 sections dealing with the attack against the woman. But if you say 376 rape also there, it is for the judge to consider whether this allegation would amount. Therefore, to some extent, the social media, instead of educating the larger section, was also trying to sensationalize issues. It is not just a layman's understanding. It should be an understanding in terms of law, what is a rape and what's not a rape. And therefore, we should not superficially argue on judgments. The other important case is a cash seizure. We do not know whether cash has been seized or not. If it is seized, what is the amount? It means who owns the cash. Now there are many things. When a cash is seized from a politician, nobody gets a doubt because it becomes an ordinary matter. If a dog bites a man, it's not a news. If a man bites a dog, it's a news. Therefore, if a cash is seized from a judge's house, now that it certainly becomes important. Now, what is the machinery that is available to find out? And then, if the judge is wrong, how to punish him? Our constitution provides only impeachment. There is no other method. Judiciary has evolved some in-house procedure. Some senior judges will inquire into the issue. Even then, they have to suggest only ask for resignation or tell the parliament to impeach. The impeachment is the only method by which a judge can be removed. But this is not the first time when cash is involved in the judge's house. A few years back, in Punjab and Haryana, a parcel was delivered in a wrong house. There were two women judges. One was Nirmal Gaur, other one is Nirmal Yadav. This man who went to deliver, he delivered the parcel to Nirmal Gaur instead of Nirmal Yadav. If he had delivered correct house, nothing would have come out. Now, Nirmal Gaur got a little upset and then immediately got his police to arrest that fellow. And then they found out this parcel will have to be given to Nirmal Yadav. Now, when the issue came, as usual, there was a 3-judge inquiry, and the inquiry committee found prima facie proof, and CBI was asked to inquire. CBI also filed the report. Now, under the law, if a judge is involved in a corruption, you will have to take the permission from the Chief Justice of India. The Chief Justice of India refused to give permission to prosecute her. Now, Nirmal Yadav went to Himachal Pradesh, happily retired. There is no criminal case. We do not know for whom this 15 lakhs is meant, whether it's amount to a bribe, a post-bribe decision or a pre-bribe decision, we do not know. But then the system of cleansing the judiciary is not very happy. In fact, when Bharucha of the Bombay High Court said our 60% of our higher judiciary is corrupt, then somebody later asked another Chief Justice. He said, Bharucha may be right, but now it is on the higher side. So nobody ever denies that there is no corruption. Everybody knew there is a corruption. The question is how to weed out corruption. Right from recruitment to superintendents to many methods which are still not only adopted. Initially they thought all judges appointed will be good judges. Now that seems to be not really paying, and therefore the transfer, I transfer somebody, there is a complaint. Now the question is the transfer an answer? Now the transfer place they are protesting, saying we are not a dustbin to send to our court. There are many issues which are yet to be resolved, and this is not an issue to be only left to the judges. The issue to be debated on a wider angle. And accountability of the higher judiciary and the method of recruitment to higher judiciary both has to be looked into. The third question is on what should be the remedy for anti-conversion bill. It's no longer a bill. At least in 5 states it's a law. Some states are still looking for a new law. Now the conversion law, look at it. How far it is constitutionally valid is an issue now. Now, the Constitution provides for conversion, having faith, then belief, freedom of conscience, and also propagate also. It's not as if mere passive belief. You can propagate also. If that fundamental right is there, how do you support conversion? They say no, there is some material incentives are coming, and therefore we want to stop this. This is their argument. In fact, you should recall the dialogue between Mahatma Gandhi and Ambedkar. In fact, Mahatma Gandhi wanted an audience with Ambedkar, and finally he met Ambedkar. And the discussion went on conversion. So Mahatma Gandhi said, I don't want conversion. I don't believe in incentive. This is what he said. For that you should see a brilliant reply from Dr. Ambedkar. He said, Babuji, you don't consider us human being. Whether we take money or don't take money to go to some other religion, this is how's your concern. Unless you treat me as a human being, the question of you are getting worried about conversion need not be there. The one issue which is still there, haunting everybody, that we are only stopping the material incentive being given for conversion. Now, what is material incentive has never been there. Because once upon a time, it was a missionary education which brought education to many places. In our place, but for the missionaries, we would not have got to school at all. We would not have denied education at all. Now, is that a corruption? Or health? Or many issues for that matter? Anti-conversion bill is only for the purpose, though it has been upheld in the Orissa case, the Stanislas case. It has been upheld by Supreme Court on very narrow ground. But a time has come to look into it again, to find out whether it is trying to browbeat the minorities. That's a main issue. Because there are judges and there are RSS exponents who now say, in fact, one judge from the Madras High Court speaking in Delhi, he said that on 15th August 1947, the ratio between Hindus and Muslims, if it is not continued even today, then it is time to shed this constitution and go for a new constitution. A sitting judge saying all this, as if there is a proportion and there is a growth. On the other hand, today's population growth now, as today in the Madras Chief Ministers meet, the South and North, the Hindus of the North are having more children. The Hindus of South are getting less children. Now there is going to be delimitation. Then it is punishing the South. That is the argument. Therefore, these are all endless arguments. I am only saying the religious conversion is also used as a bogey to threaten people to change religion. Now, the argument of incentive has to be gone into, and that cannot be gone into by a district magistrate. You can't go and register saying, I want to go there to register. Then what is the faith? What is the freedom of conscience that you are not promoting? Why I should get district magistrate permission? And suppose after 1 week of that faith, I come back again, then what happens? And you know there are 2 cases in India. The Arabindo Society case in 83, where Indira Gandhi appointed administrator, that was challenged. The Arabindo Society argued, we are not Hindus, we are a minority religion. We are a different religion. We have nothing to do with Hindu religion. In West Bengal, the Ramakrishna Mission argued and succeeded before the Calcutta High Court that we are a minority religion. All only to control the educational institution, the institution which they are running, not for the view. In that case, Justice Chandrapurati put a very dissenting judgment, but he asked the question, is there only one religion in this country? Can there not be different religions also? In America, you will have a charismatic leaders having different groups also. Now, if the constitution has to be widely widely interpreted, and 25 means different. This conversion bill is really a fraud on the constitution. Again, the Supreme Court is upheld by 2 judge bench. It has to be seen again whether it still stands the constitution. And one more question. I think he gave me a critic of Abraham. There's another question which is by what really troubles the present regime of civil attack on constitution. Now the question will be, when a rule of game is not followed, it's a foul game. Now if somebody wants to play a foul game, they start with the changing the rules. If the rules are not happy, they abandon the rule itself. And therefore today is a talk that we need to have this constitution overall. There have been several attempts from emergency to now. At least 3-4 times there has been attempt. And last month, after the Kumbh Mela, some of the priests have formed a committee. They want the Hindu constitution. Now, what is the Hindu constitution? Hindus alone can vote in this country. What about Muslim Christian? They can live here, they can do trade, they can do education, but they cannot vote. So now they say we will take this to every village and then convince people that we need a new constitution. The moment they start talking about new constitution, we'll have to find out what's wrong with the old constitution. If nothing is wrong, then we'll have to defend the constitution. The question is that the constitutional debates are still only left to the court and some political meetings and not wider level. In 2025 election, and that was the main issue, where people were able to take that this constitution should not be allowed to. The constitution is put to test, and therefore, I think to some extent, the results show by giving minority status to the BJP party, changing the structure to a different structure, to be minority so that there is a more safety for others, is something, a lesson which the people have realized. And this debate has to be intensified. What means secularism, what means socialism, or what means federal structure? Now somebody asked the question on Kashmir. Kashmir, we can still have a debate. Now if the constitution is not a document produced by majority, constitution is a contract, constitutional assurance to the minority, then 370 can't be removed just like you remove some pad from your body. That's not the issue at all. And how much debate goes on this? This is major issue. Now today, constitution is something left to the legal pundits to argue. Now I feel today constitution become a document of an ordinary people, where each person can question, and it's a matter to be debated in streets, and a matter to be decided at the time of election, and therefore this has to be done. And Kerala government has done a human service by taking the constitution to the schools. I think we should start the debate. Whenever I go to many campuses, I do discuss on the importance of constitution, and the students do believe that they have a role, especially after the amendment came. In fact, the first Saman Mukherjee amendment of 72, he asked for reduction of 18 years. That came only after 1999 when Rajiv Gandhi became the Prime Minister. Today, every person who is 18 years can vote. If he can vote and elect his leader, why he does not discuss about what the leader should do? This is something which we will have to take into the wider audience.
Thank you, sir. I hope he touched all questions and queries. Now I invite our treasurer, Sujata Devi, to conclude and deliver the vote of thanks.
Good evening, everyone. On behalf of Janasamskriti, I would like to express our heartfelt gratitude to all those who have made today's event a success. Firstly, special thanks to our distinguished speaker, Justice K. Chandru, sir, former judge, Madras High Court, for sharing their valuable insights and expertise with us. Your lecture was not only informative but also thought-provoking, and it has certainly left us with a lot to reflect on. We are grateful for the time and effort you put into being here and for delivering such a compelling speech. We would also like to extend our sincere thanks to all participants who joined us today. Your active engagement and thoughtful questions have added so much value to this session. It is because of your involvement that today's event has been so productive. Lastly, thank you to everyone here for your time and attention. We hope you found today's session enriching as we did, that you take away valuable knowledge and insights that will contribute to our growth. Then special thanks to friends and the friends from other progressive organization. Our sincere thanks to media friends who came for today's program. Our sincere thanks to officials of Constitution Club for allotting this venue. Then thank you once again.